Hello and welcome to today's session of German Law in a Nutshell. My name is Conor Pottgieser. I'm a solicitor here in the Stuttgart area, and we predominantly advise family businesses which are so famous for the Swabian, for the southwestern part of Germany. Today I want to talk to you a bit about terms and conditions under German law. German law is supposed to be very complicated and strict, and to some degree this is correct, but there are nevertheless possibilities to have good terms and conditions. So how does that work here? Terms and conditions may not be inappropriate. They are not allowed to discriminate unduly the other party, to be unfair. This is the main reasoning of German law. And how can you judge that? Well, maybe you put yourself on the other side of the table and think about how you would feel if someone would impose such a clause on you. Is it unfair? Do you feel discriminated? Is it not transparent? Does it surprise you? And if you have an answer, if you can answer this positively, if you say, yes, I feel discriminated, then it is inappropriate and you have to leave out this clause, although it might be very useful for you. And further, you may know the red hand rule, which is very known in the common law systems. Clauses which are quite special may be marked to a degree that they are special. They have to be a red hand to show that this clause is special, right? You have to emphasize that this clause is valid. And if you have a non-valid clause, it always the question whether the contract is still valid. And there you may also know the blue pencil test. So with this blue pencil test, it is also a question, can you strike out this clause without harming the rest of the contract? And if it's possible, the rest of the contract is valid, and if not, the whole contract is void and null. So these principles do exist under German law as well, and there you don't have to think very differently. Further, so what are the major fields for terms and conditions? Well, they regulate on payment condition, they regulate on property, on the sold goods, they regulate on industrial property, on liability before all, and in the end you often have a clause for the place of where can you sue someone, and the applicable law, German law, English, Swiss, or whatever law. These are the major fields. With regard to liability, you may leave aside these clauses you may know from Californian enterprises which use these clauses very broadly and they exclude every liability of everything. This is not feasible in Europe, in Germany. You may only exclude liability for negligence of not essential duties. This is the only case which is really possible where you can exclude this liability in terms and conditions. If you have a written other clause which was negotiated individually, then it is possible to exclude more, but not in terms and conditions. What else do you have to know? Well, lastly, what is a major point always is that people forget to tell about their terms and conditions. So then some client comes here and says, well, why aren't my terms and conditions not applied? Because you haven't set a bit of them. So usually you need some hint, my terms and conditions shall be applied, and if it doesn't have that, they are not applied. So don't forget to tell your customer about your terms and conditions. So this should be all for today in German law in a nutshell. I hope you learned something. If you have questions, feel free to address us by email or other means which you can see at the end of this little clip. My name is Conal Potke, so thank you for joining us today, and hopefully we will meet for our next session in this course.